judiciary stands as the last hope of the common man. But then we ask ourselves, how well has the judiciary been able to interpret these laws? Even the laws that are meant for us as citizens of the Federal Republic of Nigeria, how well do we know these laws exist? And how well have we also applied these laws to our daily living? Now, human rights infringement is something that has been on the front burner for as long as humanity existed. The need to understand where one's rights are being infringed on, you need to understand where certain actions also inhibit your fundamental human rights. But like people will say, when you want an African man to lose ignorance, to employ ignorance, the easiest thing is to put it between the pages of a book. People do not want to read very long. But then certain statutes keep us as fundamental human beings. The fact that we have these, our rights, our human rights should not be infringed upon. I think that's the major essence of having the third arm of government, that's the judiciary. And in the studio we meet this morning to discuss judiciary as a last hope for the common man. We have in the studio Dr. Michael Afolayan, legal practitioner, notary public, and head of department of the Business and Industrial Law Department of the Ekiti State University. I'd like to say thank you very much for joining us once again on Viewpoint this morning.
Thank you very much for having me again. Good morning, and good morning to our listeners at home, at work, and everywhere you may be. Thank you.
Barrister, sometimes I feel like calling you, you are the Olori of your community or town. So sometimes I'm confused whether to call you Otumba, or to call you Chief, or to call you Doctor, or to call you Barrister.
It is well. Whichever you call me is okay, but I'm Asiwaju. Yes,
Asiwaju.
That's great.
So, Doctor, judiciary as the last hope of the common man. Yeah. We look back at the trajectory of Nigeria, the evolution of the country till now. And when we look at some of the litigations that have occurred and some of these human rights infringements, do you still think that the judiciary is serving its purpose as the hope for the common man?
Well, thank you. I guess that question borders on the assessment of the judiciary over the years, especially during the dispensation, this republic that we are in. In order to answer that question, I guess it would be fair to first of all look at the background or the backdrop against which the judiciary is expected to function. You have said it initially that the judiciary is the one of the arms of the government. I don't want to say the third, because in our bid to rate which one is first, second, or third out of the executive, legislature, or judiciary, we have arrogated, all of us. We have arrogated unnecessary power and unnecessary recognition over and above other arms of the government to the executive over the years. And I guess that is why the executive sees itself as the main arm or as the first arm of the government. But in the recent, when you look at it historically, when you look at it from the angle of even the law itself, even from our constitution, you will see that the first arm is the legislative arm of government. And our constitution, section 4, section 5, section 6, gives power to the legislature, the executive, and the judiciary. And section 4 of the constitution gives legislature its power before section 5 gives executive its power, and section 6 gave the court, which is the judiciary, its power. So even if we are to look at it that way, I would say the legislature comes first, because that is the representative of it is the people. So legislature should even be called the people. It is because all of us cannot sit down to take decision at a time. We are too many. Where will over 200 million people sit to take a decision at a time? And that is why we have to pick our representative to represent us. And that is the people. And that's why it's called the People's Assembly. And it is the first. It is the law they make that the executive is expected to implement. It is the directive they give that the executive is expected to execute. And wherever there is conflict, either between them or between private individuals or whoever, then the judiciary comes in to intervene, either to settle such disputes or to interpret law with respect to such a dispute. Now, focusing on the judiciary comprises the legal framework, that is the law, that covers the power to adjudicate or to interpret the law. It also covers the administrative body that is empowered to carry out that particular function, and it also involves every player on the feed, of that, including lawyers. Yeah, lawyers are also part of the judiciary because every lawyer is first of all a minister in the temple of justice before the duty of protecting or defending the case of your client even comes up. So we all see ourselves, and that is, the actual fact that we are minister in the temple of justice, and that is why every lawyer is expected to speak the truth and to do what is right at all times, even if doing what is right will be against the interest of your client. The worst you can do, or the best you can do, is to conscientiously step down from taking the matter of any client that will make you walk your conscience against what is a true position of thing or correct interpretation of the law. Now, having said that, the judiciary is empowered, like I said earlier, in Section 6 of the Constitution of Nigeria. We call it the court. The section says that the judicial powers of the federation shall be vested in the courts to which this section relates, being court established for the federation. Now, we have many courts in Nigeria, right from the topmost one, which is the Supreme Court of Nigeria, coming down to the Court of Appeal, then coming to the Court of Coordinate Jurisdiction. There are so many courts at that level: Federal High Court, State High Court, National Industrial Court, and so many of them along that path. So they are referred to as Court of Coordinate Jurisdiction. Then before you come to the inferior courts, inferior courts are courts from magistrate, area courts, customary courts, rent courts, even the environmental court, mobile court, all of those things, depending on the creation by a state. All of those are referred to inferior courts of record. Now, over the years, I'm coming to the assessment now. Maybe shortly before I come to that, let me look at the power that is given to the judiciary. Now, the power that is given to the judiciary extends to intervening or coming in to interpret the true position of the law whenever there is disagreement. Don't forget, Nigeria is a country that is based on rule of law, not rule of man. Everything you do must be backed up by a particular law. If it is not legal, then it is not doable. You can't go there. And so if it is illegal, it means that it is not in line with the law. And so the court is called upon from time to time to interpret what is the position of the law with respect to disputes that may occur between arms of government, between individuals, between government and individuals, fundamental right issue, and so many, even civil rights, individual rights, and all that, between me and my neighbor, between me and my wife, and and so on and so forth. And the essence of this is to ensure that that we have an avenue where people can vent their displeasure. If people have displeasure, even at homes, if someone has a displeasure, even if it's a child, and you don't give such a child the opportunity to speak out, to vent out, you eventually get to a situation where one day, whenever, the day that such a child or such a person will burst out, you will now have a accumulation of anger that you will be wondering that, is it this little thing that has been done to this person that he has, gotten this worse? What did they do to him that he cut off the head of somebody else? But you don't know that over the years he has been complaining, he has been lodging, but he has not been allowed to speak out. But where there is an opportunity, even when you are boiling the water on the fire, even a kettle has a mouth where the steam can come out from. If the steam cannot come out, the thing may likely burst. And that is exactly what the situation will be if there is no judiciary. It is there for people to vent their anger. It is there for people to come out to say, I've been wrong this way. I don't think the government is treating me right. I don't think my husband is treating me right. The way this person is handling the contract we have together is not good enough. I want the court to come in and this and that. But you see, over the years, we have had so many challenges, not only with the judiciary in Nigeria, but all over the world. But let's be particular about the ones we have in Nigeria. Yes. You see, one of the biggest challenge that we have with respect to judiciary is the fact that these judges, these magistrates, and by whatever name they are called, caddies, grand caddy, whatever they are called, sitting on the bench and taking decision on matters that affect life of persons, they are human beings. They are human beings. One of the first things I learned in my study of law is that judges are human beings. There are times that the human part of us takes the better part of us. Don't forget that while you are expected to interpret the law, you will definitely bring your own understanding, study, idea, how you interpreted the law to mean to bear. And that means you are exercising what is called discretionary power. There are areas where you have to exercise discretionary power. Even though there are areas where your hand may be tied as a judge. You know, somebody raised it in one of the programs we had there, that a judge said, my hands are tied and this and that. Yes, your hands may be tied because the position of the law is very clear one. Even though by sentiment, you are thinking as a human being that it is unfair, because there are times you have to apply the law that it will be kind of very, very, formal, and the human part of you is saying, why not permit this thing to go? But because you have to do your job and you have to do it in line with it. And don't forget that these judges too, magistrates, whatever their names are called, they also have their disciplinary body. They are also monitored. Whatever they do, they can be taken up on it. So, and that is why they have to keep, to the law. And so there are times being human on the bench may make you do things that you ordinarily don't want to do. It may make somebody who is wayward. Maybe we should not use that word, strong word. I think it's a strong word, wayward. You wanted to be, because as a human being, okay, let me give you an instance. If as a judge, you've had 2-3 wives, and the reason why you've had 2-3 wives is because the first one you were having issues with her. You married another one. That one you were having issues with, you married another one. Along the line, you have divorced like 1 or 2. You have 2 or 3 other side chicks outside. Now a man has approached you. He wants to divorce his wife. You are likely to see that matter from your own experience of life. That you may not say it out, but definitely it will kind of affect your impartation or your reasoning. And so eventually it may not take you 3 months to divorce both of them. You go your way. Now look at a judge, for example, he's a Catholic. He has married one wife all his life. He has never had reason to cheat on his wife. Now a matter has come before him or her that has to do with dissolution of marriage. And so you see him trying to persuade you. Is there no elderly person in your family that you can bring to this court that I can ask to intervene and wade in what happens to your children, and this and that, and you may be on that for 3 years. So human being, I'm just citing that as an example. As an example. These people are human beings too. They are not angels. Even if you bring angels to give judgment, people that will be unsatisfied will still be unsatisfied, because once you don't win, you believe something has gone underhand. So that is one. Then number 2, we may also have to look at our political system, political interference in matters that ordinarily we should allow the true position of things to play out. There is hardly any case today in court, even at magistrate court level, that you won't see one politician or somebody somewhere who knows someone, or someone who knows someone who knows someone who is interested. And then you see different calls. You see a court sitting and then having to rise to attend to an urgent matter. Is being called on that same matter that is before him. In fact, I don't envy judges. I don't envy magistrates because of the pressure they have to go through with respect to matters before them. I've had to listen to stories. I've had to, interact with some of these people, and I know the pressure they go through. And this is more so in Nigeria, where we believe everything must come our way because we are politicians, because we are the people at the helm of the affairs. So, and you can't rule it out. We have had judges who have had to be shown their way home because they've danced to the tune of politicians in this country, and they allow that to affect, the course of justice. And so this is another challenge, and we have so many other challenges, which we cannot even, exhaust on this program. So assessing the judiciary in Nigeria over the years. I would say we've had the good, the bad, and we have the ugly. Yes. And recently, I've had cause to come here to speak on the value-added tax judgment between Rivers State and the federal government. And you see, a judge of the Federal High Court gave that judgment, which we can say was against the federal government anyway. And that is to tell you that a judge, once he sits on the bench, is no longer a judge of either the federal or a judge of the state. He's a judge of his conscience, and is a judge to uphold the rule of law. And that is why they have their code of conduct. And so they are expected, because once you are on the bench, even your exposure to people is, you are to limit it. Attending parties, attending this, attending that, so that it is not because they don't trust in your ability to do your work. It is because the mind of man, for example, you have a case with another person, and then you went to a party and you saw the judge in that matter, who sat on that matter, sitting with the wife or the friend of that your adversary, eating together on the same table. Your mind is quickly raising that they are already discussing that matter. And before you know it, if it goes against you, I saw them that day. And that is why, all of these code of conduct are there to say judges should refrain themselves from doing a lot of things, even magistrates and all that. But they have their challenges too, over the years, which may have also affected their performance. But up and down, I would say that the judiciary in Nigeria, except we are now going to specifics now, I would say that on the maybe of a scale of 1 to 10, 10 being the highest, I would say the judiciary has performed up to 6. Up to 6.
Now, the people, ultimately, when the people bear the brunt of any policy or any judgment that's put in place by any judge, when you talk of court processes and all that, they say the easiest thing to do is to have to encourage ignorance, is to put things into a book for Nigerians.
Yes.
Now, a lot of Nigerians don't even understand some of these laws protecting them. Legal education is something that I've had cause to advocate sometimes on this program with a lot of other of your colleagues. The need for people to be aware of legal interpretations, to be aware in specifics. Sometimes when I go to court to cover court processes, I find out that some of the English and the language being used there is so easy to hoodwink anyone. People are tired of easily get
legal jargons,
all the legal jargons and all that. So we ask ourselves, at what point does bringing, they said Muhammad was made for man and not man for Muhammad. Look, there's a certain diction like that. But how do we ensure also that people get abreast of legal matters? How do Nigerians have a situation where you can understand the legal processes also, and you can be interested? Because a lot of people are not even interested. So you find out that a lot of social injustice is being meted out to people on a daily basis, but just because they do not understand the legal consequences, they don't even approach a lawyer or even a court of law.
Yes, well, I understand that. Let me come in this way. You see, first of all, in Nigeria, there is this presumption under the law that everyone is presumed to know the law. And that is why we used to say ignorant of the law is not excusable, although ignorant of fact may be excused. What that means is that you cannot come to court, or you cannot be brought to court, and then some laws are read to you that you have violated it, and then you are excusing yourself, or you are telling the court that I didn't know that was the law, I've never read it before. You will not be excused. Everybody is presumed to know the law. And what that means is that every person in Nigeria should try whatever is necessary to make sure that he understands the legal implication of what he wants to do before he dabbles into it. Let me give you an example. Most people in Nigeria, or in Nigeria today, when they want to buy land, they would have purchased that land, at least out of, let me say, out of everything, 8 would have bought the land, would have paid for it before they start calling you. In fact, most of them will not call you as a lawyer, and they will now call you to say, I bought a land. Somebody told me that I need to sign a document. Will you sign it for me? In fact, some of them would have even prepared something. They said they wanted to sign it. And you see, the amount you spend to avoid a problem when it comes to legal matters is not even up to 1/10 of what you will spend when that thing boomerang into a problem in your hands. You will not know the position of the law except you ask someone who knows about it. For every lawyer you see on the street there, they spend 6-7 years to become a lawyer. And that 6-7 years, they only got enough to earn the certificate they are carrying about. It doesn't mean that they now know all the law. A lawyer study for the rest of their life. Awolowo till he died was reading. Even as a senior advocate of Nigeria, you continue to study. And new position of the law comes in, every now and then. But you see, the challenge we have is that most Nigerians don't even bother to ask, what is my right? What do I do about this? I want to get married. What do you even know that once you get married, if you have a will before, that will is no longer valid by virtue of that marriage, and you have to do another will? And you know some of the legal implications. So most people, the challenge they have is that they don't bother to ask. And some that may even want to read on their own, you can't possibly read the position of the law on everything, because even a lawyer does not know all the laws. It is only when a lawyer only knows where to find the law. It is not as if he carries it on his head. If you ask me a question, then if it is not something I've come across before, I know where to find it. Within the next 1 hour, I can study that and tell you what's the position of the law on it. That's what a lawyer is. So, you see, people need to begin to, approach things by looking first at the legal implication of what they do before they rush into it. And that is why most people buy litigations. When they say they are buying land, for example, or when they say they are buying other things, they buy litigation because they don't even have a lawyer. Every person is expected to have, or every family is supposed to have a family lawyer, or to have someone that you call to ask questions, questions like that. Now, coming to the issue of how people can, get to know about these things. I know that in universities, for example, in my 100-level days in the university, there was this citizenship thing, which was like a GST. There were, you find these things in bits all across curriculum, in primary, in secondary, in university and all that, so that people can get to know at least their rights and some of these little things. I guess one of the things we can do is to begin to bring this into, different level of education, so that people, irrespective of what you are studying, at least you know some legal aspect of whatever you are involved in. And then probably, if it is possible, at primary level, because you discover that whatever you know at primary level when you are still young tend to stay with you for a very, very long time, like fundamental rights and all that. These are things that people can download even on their phone and study. For example, if you ask some people, I know my right, what are your rights? Maybe it tells you 1 or 2 and that's the end. Whereas if you read from section 33 to section 44, 45 of the Constitution, you see all these things there, which you can download on your phone from Google Play Store or wherever. So, but you see that, many people are not interested in this. It is when it becomes an issue that they want to, dabble into, calling a lawyer and seeing how it can be resolved.
Now, I'm asking you this question because a lot of issues at the lower tier of government, and now we'll talk about politics later, about the judiciary and democratic process, but then we look at the environment, the community that we are. Some people are not even aware that there are certain statutes that do not, there's a limit to which a man can even maybe threaten his wife, or even apply corporal punishment to the mental corporate punishment of the children, even laws regarding neighbors and how boundaries and alienations also. People hardly know all these things. Now, at what point do we think there will be a need for people to be able to have a handbook of what really is your law? Just let me give you a quick example. So you are walking along the road, you step on someone and he slaps you viciously. As a retributive justice for what ordinarily would have been, I'm sorry, and let it go. And somebody slaps you. Some people would just say a crowd settling it, and the person walks away. But then later you go to the hospital and find that you've been injured. Maybe you are your ear. So people don't even know that daily scuffles are things that can also have illegal implications.
Yes.
That's basically why I'm asking that question. Yeah. So at some point, if you say, because we have to understand also that we are dealing with the public that is not too literate sometimes.
Yes.
So even the people who are illiterate also have a right to get access to justice. Yes. So that's my major concern.
Well, I guess everybody has a duty along that line. And let me speak about your own duty. I think you are also performing your duty along that line now, because I'm aware that on all radio station, television station, they usually have a section for you and the law, you and your right, things like that. And I guess we only need to talk to people to be interested in things like that. You know, many people tend to wave, you know, when it comes to legal matter, they tend to wave it with the back of their hand. What are they all doing? Maybe they are all, you know, this and that. You just categorize everything, not knowing that what they learn along that pattern can also help them. You may not be in that situation now. Do you know that the court is even a public place that you can just walk in and sit down to listen to any matter at any time? Anytime.
You could easily get access to any court
Anybody. You can just walk down to Fajui now. Any court you see that is sitting, you can walk in and sit down and listen. So there is nothing that stops anybody from doing that. For example, if you have a family or a lawyer who is your friend, you can ask questions. You know, ask. Yorubas will say abere ona unshina. And that was why the first thing I said was that people need to begin to learn to ask questions about the legal implication of whatever they want to do first before they do it. Even at times you discover that the little amount that people will spend on preparing the document that will secure them with respect to a contract they want to, you know, enter. They say, I don't want to pay lawyer Jare this money. And then it's not as if I'm speaking for lawyers, but I'm telling you, you know, issues, live issues that I've seen that, you know, boomerang later that, you know, people will now be trying to mop up the effect and, you know, here and there, whereas it could have been avoided all along from the beginning. So I believe that apart from, you know, this aspect, maybe in the education system, we can begin to look at that. And, you know, probably if you have the opportunity and you bring, you know, those who are on that line here, you can, you know, ask them questions. What are you doing to educate the public? Yes. And we also have so many NGOs who are also doing that, coming to the radio, TV and all that, and then providing flyers, you know, to provide legal information on various legal issues.
Another issue there that I'm very concerned with also is access to justice. Now, I've heard of very extraordinary fees that barristers and lawyers and judges charge for cases. Now, we have to take into cognizance that a lot of people are living below the poverty level in Nigeria and even in Ekiti State as a whole. So, access to justice sometimes can be made almost impossible by a client not being able to pay these legal fees. Now, that's another area that I'm very concerned
I understand.
about. Access to
justice.
Cheap access to justice.
Yes. Well, you see, this issue of access to justice has always been there. People have always been concerned. We've had so many NGOs working on that. It is true that in Nigeria of today, it is not cheap to get justice because the cost of hiring a lawyer, the cost of filing court papers, the court, you know, the time that it even takes you to, you know, go through a matter in court and this and that, they are all there. Yes, true, it's there. But also don't forget that these are also factors that people, you know, issues that people can factor into their own budget. As if, you know, for example, you want to go into a business. You can factor the cost of your lawyer, for example, maybe who is on is on a retainership with you. You can factor it into your the cost of your business. But for individuals who are living below poverty line, who are finding it difficult to, you know, pay, and they are going through such challenges, I believe that there are so many other outlets too that are free. For example, we have lawyers who do pro bono matters. Pro bono means free. For example, I do a lot of that. You know, that you don't charge them professional fees. Or even if they have to spend at all, they only spend maybe administrative charges and all that. Yes, people do a lot. For example, you have people who are in court who are charged for criminal matters and they don't have lawyers and they don't have money to, you know, get lawyers. Most of them are in the prison. And you discover that, you know, at times we step in. There was a young boy, 18 years of age, who was thrown into prison here on the allegation of armed robbery, which I stood for free. And then eventually we got him free after 3 years. I did not take it. In fact, I was the one giving him money whenever we come to court. So, and at times I just look at the situation and, you know, I cry, you know, of situation he was going through. We have so many lawyers like that outside. In fact, as a lawyer, one of the things that is expected of you to do before you can become a senior advocate of Nigeria is that there is a number of pro bono cases, free cases that you must have done for people. It is part of the requirement to become a senior advocate of Nigeria. So,
corporate social responsibility.
Yes, you do for individuals, you do for, you know, we have a lot of people doing that. It's only that people just make up their mind that they will charge me, they will do that, and that's why they don't even bother to call. I have a lot of person calling me. to ask what is the legal implication of this. For those who I cannot avoid, I may have to. But even though it is required that such persons should, come to your office and then pay consultation fees, but at times we overlook that and then, still give advice. So what I just want to say all in all is that people should learn to make lawyers their friend, ask questions, ask legal questions. The tendency is that if you call three, at least one of them will probably answer you and then give you direction.
I'll let the phone lines open before we go to the next part of the discussion segment, which I'm sure a lot of people want to talk about, and that's the judiciary and the democratic process.
Yes.
But let me take some more calls if there are people who want to ask questions or have observations. 08039771069. That's 08039771069. You can also join the conversation on 08111981069. I'll take those numbers again, 08111981069. And we have our first call on the program this morning. Hello, good morning. Good morning. Your name and where you're calling us from? I thought so too. Good morning, Ms. Hala. Your contributions or questions, please.
I want to ask questions from our lawyer. Why is it that when some people were taken to court, they asked to go to either remand or prison, and for years the case will not come up again to finalize whether it will remain in the prison or what we call it.
Remand. Maybe I should start from the last one that she asked. That when you know that somebody is already guilty of a matter, that why do you still defend him?
Let me take this one so you can take both questions.
All right.
Hello, good morning. Your name and where you're calling us from, please. Okay, Agbakoko, Ondo State. Your contributions or comments? Thank you very much. Thank you. Thank you. Thank you very much for your questions. I think that's almost what Monisha was
Yes,
saying.
they are virtually along the same line. Let me say to start with, that there is no case that a lawyer is expected to assure his client that he is going to win this case. In fact, it is a professional misconduct for any lawyer to assure his client that this case you have brought to, I'm going to win it. We are going to win. No, it is never to be done. In fact, it is a professional misconduct, like I said earlier. You can only say we will try our best because you are not the judge and you don't know what the other side is going to say. Most of the time when a client comes to you and they say this is what happened, this is what happened, it is only when you see the evidence that the other side has that you realize exactly what is the true picture. Because ordinarily a client is not expected to lie to his lawyer, but you find that happening in virtually most cases. There are facts that you may not be aware of until you get into the midst or the middle point of the case. That being said, secondly, the aspect that was mentioned by, I think, Mrs. Monisola about people being thrown into remand, for a very long time and all that. Yes. Don't forget that when it comes to criminal matters, when anyone is accused or reported to have committed a crime, the police come in, they arrest such a person, they conduct their investigation. After their investigation, if it's a matter that they want to take to, for example, it depends on the offense. If it's a simple offense or a misdemeanor, they may decide to charge the person to court through the police prosecutor by themselves, which means that the police may by themselves conduct the trial. If it is such a case, they just simply go ahead, charge him to court, and then their prosecutor takes it over. But there are some cases that are not within the jurisdiction of that a magistrate cannot hear. For example, when it comes to murder case, armed robbery case, rape, and quick matters along that line, such matters, when they are taken before a magistrate, because there is also a limit to which the police can hold on to an accused person. Within 24 hours, they are expected to take such an accused person to court, if there is a court within a 48-kilometer radius to where he was arrested or he is being detained. And when such persons are brought to the court, most of the time investigations are yet to be concluded. So because they have to bring him to court within 24 hours and they can't conclude the investigation within those 24 hours, you discover that when such a person is arraigned, if it is a matter that is ordinarily bailable, there are offenses that are bailable. There are offenses that are ordinarily not bailable. For example, if it's a murder offense, rape, and all this, they are not. It's not as if you can't apply for bail, but not at the magistrate court anyway, because magistrate does not have jurisdiction over them. So all that a magistrate can do is to give the police the power, or because the police can no longer hold the person beyond 24 hours, is to ask that the person be remanded in prison custody, pending the time that they will conclude their investigation, and then they will be able to file, information at the High Court that has jurisdiction to hear such matters. Even where the matter is before a magistrate and the magistrate has jurisdiction over it, the accused person, once he is brought before the court, is expected to attend court at all times that his matter may come up before that court. And in order to ensure that he attends to his matters, there will be need to admit him to bail. If they are going to admit such an accused person to bail, there is a need for someone to stand as surety to the accused person that we give an undertaking that I will be providing him. I will ensure that he attends in the court. So most of the time you discover that when an accused person is even granted bail, there are times that the magistrate may even grant bail even without a lawyer appearing for him. They may grant him bail, but you still discover that there is nobody to perfect that bail. If there is nobody to perfect the bail condition, to sign the bail bond, to say, okay, I will produce him, then of course he will have to be taken to the prison, and he will remain there until he is able to provide someone. There are so many of them in the prison there who have even been granted bail and who are not able to perfect their bail condition. At times, because of the offense, that an accused has been alleged to have that is accused to alleged to have been have committed, you discover that the nature of the bail condition that is given to him is such that he will need, at times he may need a traditional ruler to stand for him. At times he may need as surety because of the gravity of the offense he has committed, even where it is granted by the High Court. Most of the time they don't get someone to stand surety for them, so they will remain there, like the case I mentioned to you earlier, that the boy was in court for like 3 years. Within 8 months of his being remanded, I applied for his bail. He was granted bail at the High Court. But the condition that was attached to his bail, one of it was that he has to provide a civil servant who is of level 14 or thereabout. But till we finished that case, he was not able to provide such a person. So it was when eventually we won the case that he got out of the prison after spending 3 years there. So these are procedures and procedural rules that we have to go through, that you can't really fault when it comes to the issue of. And I think the other aspect that Ms. Okay,
we have a caller. Hello, good morning. Hello, your name and where you're calling us from, please. Mr. Raphael, a quick one, please.
Yes, I want to comment about the time. I want to simply have a question that relates to marital issue and the issue with divorce between husband and wife. I believe from my own perspective, maybe I'm right or not, that when the issue of divorce comes, they usually favor the women. Irrespective of maybe the woman is 80% part guilty of the accuse, of the offense between the husband and wife. Why is it so? If perhaps I'm correct or not, I want the barrister to
Thank you very much, Mr. Raphael.
Yes, I believe that that position is not correct. I've had cause in the past to appear for a man in the divorce matter, or many men in divorce matter. I've also had cause to stand for women. So, and I understand from my own practical experience that it is not like that. It depends on the facts that you are presenting in your case. It is not just about being a man or being a woman alone. If you have a matter, a divorce matter at that, and you don't have evidence to provide that this is how it happened, even though you are saying this is how it happened, but you don't have evidence to provide, it will be. Don't forget that we also have judges who are men and who are women. The same way we have magistrates who are men and who are women. So I don't believe that is the true position. I wouldn't know which particular case he is talking about, because people can also talk about their personal experience. And don't forget that I've said it earlier, that these judges are human beings. So, but generally speaking, I would not want to agree with him that is the position of things. It depends on what you are able to present. And don't forget that this is Africa, where we have domination of man over woman in a marriage.
Exactly.
So in most cases, you see that it is the women that come to court to complain. And in fact, we have many women who are also suffering within their marriage, but because they want to remain, because they want to protect the interests of their children, they want to stay there to ensure that their children get the best that they could get, even though they are suffering from it. So, but in most cases, for a man, before a man will go to court to say, I want to file a petition against my wife, you discover that it is either he wants to remarry. I'm not saying that is the case in all of the cases. He wants to remarry, or the woman has gone away, and then he just decided that I have to free myself and do this and that. But for a man to be going through suffering, or that his wife is beating him, or that the wife has been maltreating him, although it's not as if it doesn't happen, but the rate is not as high as that of women who come to court too. So if you put the data on the table, definitely it will be in favor of women.
We have another caller. Hello, good morning. Your name and where you're calling us from. Your contributions, please, or questions. Thank you. Talking about when it comes
The
to
case
matters
of
involving judges and all that.
Nogen, yeah, the CJ, the former CJN.
Mm.
I understand. Don't forget that the former CJN Onogen went to court. He went to court to challenge all of those things that happened along that line, and judgment was, given. I think at the Court of Appeal, the matter was thrown out. Politics in Nigeria, I've said it earlier. I said politics is one of the things that affect the performance of the judiciary in Nigeria, and I have no apology on that. That's the true position of things. Even though not all the judges yield themselves to the manipulation of politicians, we still have some courageous ones. Yes, courageous ones. Even though we still have bad eggs, among them. You really can't separate politics from the office of that CGN at that time. The reason being that when it was time that they wanted him out of the way, they had to go into his past and then bring out issues that had to do with declaration of his properties, especially at a particular time, and then you discover that if anybody and that's the bottom line is that anybody that wants to be a judge or that wants to be a magistrate must ensure that he lives above board, that you don't have, things that can be used against you or to blackmail you. When it comes to blackmailing, that's what politicians do to survive. They blackmail one another, and they will not hesitate to blackmail you as a judge if you have such dirty things in your baggage. They will point at it, and they will use it to manipulate you. And then at that point, it will be difficult for you to say no. And that is what they do. And not only in Nigeria, they do it even in advanced countries. So, and that is why that seat, it is not for everybody. It is not even something that, and I think one of the things that affect us in Nigeria with respect to judiciary is the idea of appointing people based on patronization or patronage. He's our person. No, he has come to prostrate for us. Let's appoint him. Definitely it will affect, later in life.
Hello, good morning. Your name and where you're calling us from, please. Ayeni from Ikere. Could you please turn down the volume on your radio or just step away from it?
Yes, sir. Thank you. Yes, I'm listening.
Thank you very much for your question. Thank you very much for your
Thank you very much. Number one, in Nigeria today, Section 36 of the Constitution says nobody is guilty until the court pronounces him guilty. So if somebody says, I committed a crime, he is not yet guilty, even though he has said I committed a crime, until the court pronounced him guilty. That's number one. Then number two, even for someone who has committed a murder and has confessed to it, it still requires the appearance of a lawyer for him before his matter can even be, proceeded with in court. And that is why where someone has committed an offense that is as heinous as murder, and he appears in court, and they ask him, where is your lawyer? And he says, I don't have a lawyer. That the judge will not go ahead with the matter until a lawyer is assigned to him, because it is the requirement. If we say because everybody confess, or because somebody is obvious, it is obvious that he committed the crime, so we should not have a lawyer, what of the day somebody is framed up? What of where you meet someone with a gun somewhere and you saw somebody lying in the pool of blood, obvious that he was the one that killed the person, but it was framed up because it could happen, except where people are saying they have not seen it up to that point. Anybody could be framed up until you hear his own side of the story. Even where he now comes before the court to say, my Lord, I did it and I am guilty, you still allow him to make a plea of allocutus. Allocutus is plea for mercy, plea for leniency. So you need a lawyer to do that. And that is why it's not as if you can't conduct your own case yourself, but it is the best that you have a lawyer on your side.
Dr. Afolayan, definitely we know that this is not the end of this topic. We've talked about the rule of law, judiciary and democratic process is something we still have to do. We have a lot of callers also due to time. We cannot continue, but definitely in the coming editions we will have a part 2 of this series, the judiciary as the last hope of the common man. Let's say thank you very much for coming on the program today.
Thanks for having me.
Out of your busy schedule to have time for us at this topic today. For the past 15 minutes or thereabouts, we've been talking on the topic judiciary as the last hope for the common man. We'll definitely have a part 2, so I'm sure people that have a lot of questions to ask can still join us another later date for the program. Dr. Michael Afolayan is the legal practitioner, the Notary Public, and the head of Department Business and Industrial Law of the State University. Thank you so much for coming on the program this morning.
Thank you.
Well, here's